claim that that legislation is inappropriate. It's an appropriate use of the state board, of the legislative power to delegate to the state board what the qualitative component of education should be. May I just have a moment, Your Honor? If Your Honors have no other questions, I'll yield the rest of my time.
Thank you. We're going to take a very quick break before rebuttal, and then we'll just resume.
Ladies and gentlemen, the Honorable Supreme Court now stands at recess. Ladies and gentlemen, the Honorable Supreme Court, State of Connecticut, is now back in session. Please be seated.
Counselor, just hold up for just a second.
Sure, sir.
Thank you. Gentlemen, I have approximately 25 minutes for your rebuttal, split up however you wish.
Thank you. As far as we can tell, the proposition that the state is trying to set forth today is that so long as a building is labeled a school, it is constitutional within Article 8, Section 1. So even if students are herded into the gymnasium to be given instruction by teachers who don't have a high school education, reading 30-year-old textbooks and having absolutely no access to computers, it seems under the state's definition of what Article 8, Section 1 requires and what the principle of public education set forth in Article 8, Section 1 by the framers of the 1965 Convention and this history of Connecticut, that nonetheless, this would be constitutional within the constitutional parameters of Article 8, Section 1. And the reason they say this is because they apparently do not believe that there is any such right in the Constitution. They stated that plaintiffs are asking for what they called an unenumerated right. Well, we believe there is a right in the Constitution. It's the fundamental right to education. And this right has two components. As this court has recognized in Horton, read with Article 1st and Section 20 of the Constitution, the equal protection provisions, there's a right to substantially equal educational opportunities. What plaintiffs are asking for in this case is simply that there must be a constitutional floor, at which point the principle of free public schools is no longer met by the state's actions. And we believe that we should have the opportunity to present facts and argue this before the trial court, rather than having it simply dismissed at this early stage. The right that the state seems to be asking for is simply a right to an equally bad education, as Your Honors stated. Indeed, we agree with Justice Palmer that equality surely must mean quality. That the fundamental right to education is fundamental because it provides students with certain opportunities that prepare them for after they leave the gates of the school. The problem is not that some students are being provided incredible educational opportunities, photo labs, swimming pools, video editing suites in some schools. That is not the problem. The problem is that in some schools, students aren't learning. When they graduate, they simply cannot read. They don't have the math skills to determine where this constitutional floor should rest. That would seem to be at least as easy a determination, if not perhaps even more easy for the court to determine than this nebulous standard of disparities such that emasculate the purposes of substantial equality. Which goes to the next point, that the state seems to be arguing that so long as schools are equally bad, the constitutional principle is being met, and that it should not be this court's responsibility, but rather it should be left to the legislature to enforce the constitutional rights and protect the constitutional rights of Connecticut school children to free public schools. And this is an important question for the court to consider. With which branch of government should the constitutional rights, the affirmative constitutional rights of Connecticut school children rest? The state seems to argue that it's best to leave this question with the legislature, for it, with its unbounded discretion, guided only by the political forces which influence it, to decide what levels of funding should be provided to the towns and how those funds should be distributed.
You don't disagree that the legislature has the same obligation to uphold the Constitution as this court does, do you?
We would, and to that extent, the legislature has recognized that its understanding of the constitutional right to substantially equal educational opportunities includes this provision of suitability. So indeed, the legislature seems to agree with us that as part of equity must be this adequacy analysis. But ultimately, the question is, where should the rights of Connecticut school children rest? Simply with the legislature, or rather with this court? Plaintiffs believe that the judicial branch is specially suited to protecting the rights of school children who do not have a vote, in many cases come from communities that are politically disempowered, and may not be able to influence the legislature in the same ways as other communities. Indeed, this is the very purpose for constitutional rights, so that it is not left only to the political whims of the majority of citizens in a state, but to guarantee that every citizen, no matter what their background, no matter where they are from, no matter what their resources, is able to benefit from the basic provisions set forth and recognized in the Constitution. The difference really is between having a political backstop for the constitutional rights of Connecticut school children and having a constitutional backstop backed up by the enforcement of this court. As the court indeed noted in CCJEF, a constitutional violation demands judicial protection. And we believe in this case is similar, that just as plaintiffs' claims in Horton and CCJEF demanded judicial protection from this court, that the court should find it within its powers to adjudicate these claims.
Sorry, just to interrupt for 1 second. I know, obviously this is not CCJEF, but if we were to agree with you that there's a constitutional right to a suitable education, is it at least possible that determination would resolve the CCJEF, the definition of equal educational opportunity in CCJEF? In other words, that equal educational opportunity then becomes a suitable education.
Yes, we believe that that recognizing a right to suitable educational opportunities would address many of the possible difficulties that could arise in a purely equality type analysis. That what's important, the fundamental right to education, what's important for equality purposes is not so much the top end of the spectrum, the kinds of incredible educational opportunities that some states, or that students are receiving in some schools, but rather the bottom end of that, where students are attending schools that have unqualified teachers in overcrowded classrooms, graduating unable to read or even do basic math skills. And so, yes, we believe that this would fit well within the court's current doctrine related to Article 8, Section 1, and indeed would address many of these problems. The court also has, or the state has also talked